submitted for decision. And then after that, we will take the case under advisement and get a written opinion out to you and your clients just as soon as we can. So with that, I'll call the first case on the docket this morning. It's from Wyandotte County. It's number 125-509, entitled The State of Kansas versus Michael Edward Mastel. Council would like to come forward. And for the appellant, we have
Emily Brandt, Appellate Defender Office, representing Michael Mastel.
And for the appellee,
please the court, the appellee appears by and through Deputy District Attorney Kayla Taylor.
not positive I have your name, so.
I apologize. I filed an entry of appearance.
Oh, okay. If you do, then that's good enough. All right. Ms. Brandt, whenever you're ready, and do you wish to reserve any time for rebuttal?
May I reserve 3 minutes, please?
That is granted.
May it please the court. Emily Brandt, Appellate Defender Office, representing Michael Mastel. Unless the court has questions, I do intend to submit issues 1 and 2 on the briefs and focus my argument this morning on the 5 prosecutorial errors and then the multiplicity issue, time permitting, understanding that the multiplicity issue is truly an alternative to issue 1 and 2. Should you find for Michael on either issue 1 or 2, this court would not need to reach the multiplicity issue on the exploitation charges. As a brief background, Michael is accused of taking 3 inappropriate photos during one time and raping one of his adopted daughters, Jennifer. As a preteen/teen, Jennifer did not like the strictness of her home and wanted to leave and live with her older brother and his wife. Following altercation, wherein Michael hit Jennifer with a belt, Jennifer participated in a forensic interview. When asked whether there was any sexual abuse going on at the home, if anybody had taken inappropriate photos of her, she said that neither of those activities were occurring. She denied the sexual abuse. The physical abuse was unsubstantiated, and she was returned home. About a month later, she Facebook messages her brother's sister, or her brother's wife, her sister-in-law, advising that she had a plan to get herself removed from the Mastel's home. This is when she reports the alleged sexual abuse. Michael fully cooperated with the investigation and denies any wrongdoing. This trial was largely one of credibility, whether or not the jurors believed Michael's version of events or his accuser's version of events. And the state knew that its complaining witness had a credibility problem. Several of the state's own witnesses commented that they did not believe that Jennifer was being truthful about the allegations. So improper comments by the prosecutor in a case like this that comes down to credibility, all the way from voir dire through rebuttal closing, permeated Michael's trial and deprived him of a fair trial. And I do not think, because of the weakness of the state's case, that the state can argue that any of these prosecutorial errors are harmless beyond a reasonable doubt. And Michael would start by noting that the state has conceded one of the errors and that the state did not respond to one of the errors, and so has waived any argument that that error is harmless. We'll start with voir dire. In setting the tone for her case in chief, the state told the jury of voir dire that if it believed the child victim, it had all the evidence it needed to find Michael guilty. This suggestion that the jury's only consideration should be whether or not they believed one of the witnesses was telling the truth improperly bolstered the complaining child's credibility, and it took away from the jury its purview to weigh all of the evidence when considering whether or not the state had proved beyond a reasonable doubt each element of its charged offenses. It's actually not enough that the child might have been telling the truth. The child must be telling the truth, and her truth must align with the elements of each alleged offense beyond a reasonable doubt. And even if this error alone is not individually reversible, it was compounded by the state during Michael's case in chief. During his case in chief, the prosecutor asked a witness on cross, "Now, everything we've talked about, you weren't there when Jennifer was being raped by Michael, were you?" When a prosecutor's question is actually a declaration of its most important witness telling the truth, that is serious error. The prosecutor's question was not a question. It was a declaration of 2 things: that Michael committed this rape and that her complaining witness was telling the truth. This is reversible error. It cannot be harmless, particularly to the rape conviction.
What was the question ever answered? That first question?
I believe there was an immediate objection to the question,
which was overruled.
which was overruled.
But then the prosecutor rephrased the question.
Rephrased the question
to a proper question.
Yes.
And that was answered.
And that was answered that the witness had no personal knowledge of any of the events that had occurred. And so, which I think, again, the bell has already been rung. She's already made this declaration that her child victim is telling the truth. And again, particularly as to the rape offense, there is no forensic evidence. There are no eyewitness evidence. There is no corroborating evidence that this rape ever occurred. Again, we have state's witnesses saying they do not believe that these events occurred. The main detective on the case testified that he didn't believe Jennifer and Michael were ever left alone together for these activities to occur. And so we then see the prosecutor continue this theme of bolstering the credibility of her witnesses and giving her personal opinion about Michael's guilt during her closing. In a series of mixed, uncontroverted and controverted evidence, the prosecutor told the jury, I submit to you that has nothing to do with why we're here today. Did she want to go live with her brother? Yes, she did. Did the defendant rape her? Yes, he did. Did he take photographs of her? Yes, he did. Did Jennifer get to live with her brother? No, that didn't work out. Her sister got adopted. So we have the prosecutor commenting on the guilt of Michael, that he raped her and they took photos of her, sandwiched between two pieces of uncontroverted evidence. Nobody is contesting that she wanted to go live with her brother and that she didn't get to go live with her brother. This is confusing to a jury when you hear controverted testimony sandwiched between two uncontroverted statements, particularly when there's no backing up of why. There's no, did the defendant rape her? We submit based on the evidence XYZ, he did. It's just, yes, he did. And I think that that's confusing to the jury without providing them any of this evidence that tended to establish Michael's guilt of the offenses. And then the conceded prosecutorial error is this we know statement regarding the intent element of the sexual exploitation charges, where the prosecutor tells them, what we do know is when he was taking these photographs, that was his intent. It was for his gratification. That's the only reason you would take a naked picture of a child's vagina. It is for your sexual gratification, for his sexual gratification. They've conceded it's error to use the we know, but also beyond that, there's no trial evidence submitted, which goes to issue one, the sufficiency issue for the exploitation charges, that Michael took these alleged photos for his sexual gratification.
But couldn't the jury reasonably infer that? I mean, the timing of the photos, if I understand the facts, were that they allegedly had sexual intercourse and then he asked her to take the photos. So couldn't a jury reasonably infer his intent?
Your Honor, I don't think so, because here it's actually not a crime to just possess child pornography in the state of Kansas. You must do it with this intent to satisfy your sexual desires or your parent desires. And I don't think there's any evidence here that Michael ever used those photographs for that purpose or sold those photographs because, again, the state has alleged that he procured a performance. I don't think that we have any evidence that he used these to satisfy his sexual desires after the fact.
Is asking someone to model for nude photos procuring a performance?
Well, if it's not, then there's insufficient evidence of the state's. I mean, the state didn't charge him with possessing these images. The state charged him with procuring a performance.
Right. So if you're asking someone, hey, model nude for me while I take photos, you don't think factually that meets the definition?
I don't believe so. I don't, because I mean, I think it might meet the definition of procuring, but I don't think it meets that additional intent element of satisfying your prurient interests. So I think that we have these two intent elements within sexual exploitation of a child. You must procure the thing, and then you must use the thing to satisfy your prurient interests. And I don't think that there was any evidence to suggest that Michael used the photos in that way. And so the state is drawing the inference for the jury. And again, the state has conceded that this is error, but to your point has argued that it is harmless given the rest of the evidence. But again, we don't know anything, because even if that inference were reasonable, it's contested evidence. Michael got on the stand and unequivocally said he did not do this. So it's improper for the prosecutor to tell the jury that we know anything. And so it is error. And I don't think it can be harmless, particularly in light of issues 1 through 3 on the sexual exploitation of a child. And then finally, after Michael's attorney gets up and gives their closing argument, the state has an opportunity to rebut and gets up and misstates the evidence to the jury in a way that I think was truly confusing to the jury and in a way that I think did tip the scales of this case. She told the jury, mentioned about her having sexual exposure before because she was abused prior. Folks, the sexual exposure she got was from the defendant when he would come into her room sometimes in the morning, when she came from school and he was in his room in the afternoons, call her in there and rape her. That's the prior sexual exposure. That is not true. There is ample trial evidence that the prior sexual exposure happened before Jennifer was ever placed in the Mastel's home. And that when she made the allegations of that prior sexual abuse, she was removed from that placement.
But what exactly is the prosecutor saying there? I've got the paragraph right in front of me. And it's a confusing statement, I'll grant you that. But the prosecutor seems to be saying that Mastel abused JM over a long period of time. But I'm not reading it as that Mastel was the one who committed the prior abuse before they even adopted JM, because that wouldn't even make sense. He wouldn't have had the opportunity to do that.
Your Honor, respectfully, I think that is exactly what the prosecutor is doing, is telling the jury, because again, Michael's defense is that she knows how to make these allegations. And if she's unhappy in a placement, she knows the kinds of allegations to make to be removed from that placement.
And I get that part.
And so the prosecutor is then getting up and saying, no, there's not, she doesn't know about how to make these kinds of allegations because of something that happened outside of the Mastel's home. She knows how to make these allegations because Michael has been doing this to her for a long period of time. I believe she deliberately misstated the evidence in saying that the only instance of prior abuse was abuse by Michael, when that is simply not true. And we then have the jury during deliberations coming and asking the judge, was there abuse against Jennifer before she was placed in the Mastel's home? We'd like to know that. And of course, the collective answer is please use your collective brains to piece together this timeline. And so I think that undermines, one, I think that it misstates the evidence, and two, it undermines Michael's entire defense to say that all of the prior sexual abuse that Jennifer has endured occurred at Michael's hands, and not that she has some familiarity with abuse because of prior allegations and getting the exact same outcome in that situation, which was removal from the home, right? Again, she started here with physical abuse. She then tells her sister-in-law she has a plan to leave when the physical abuse allegations didn't work, and says, hey, that thing that was happening to me before is happening to me again, but Michael's doing it this time.
You've used 12 minutes.
Will you touch on harmless error for us? So two things, the facts, and then what is the effect of the state not briefing harmless error on the last allegation of prosecutorial error, the very last statement you covered?
Right, sure. So I think, again, the state's evidence here is not overwhelming. I've mentioned the comments by its own witnesses and Michael's witnesses that support the fact that Jennifer is not telling the truth. We have a prosecution that had to go to 2 jury trials. There was an acquittal and a hung jury the first time. We're now at a second multi-day jury trial, and they are improperly bolstering their weak case with a unreliable narrator as their complaining witness by making prosecutorial errors from voir dire through rebuttal closing permeating the trial. I don't think that we can say that those errors are harmless. And I think that because they have conceded one of the errors, which went to the sexual exploitation charges, I don't think we can say that that's harmless because I don't think there's evidence of that element. And so the state is substituting evidence for its opinion for evidence. And I think on the rebuttal closing, we have to find that comment is not harmless beyond a reasonable doubt. It clearly confused the jury and to the point that we don't know beyond a reasonable doubt that if the prosecutor had not misstated the evidence and had made mention of the fact that Jennifer was abused prior to living with the Mastels, that might have shaped the jury's view of whether or not these current allegations are true. And so I don't think we can say that it's harmless beyond a reasonable doubt. So my ask here would be, because these prosecutorial errors deprive Michael of a fair trial, the court must vacate his convictions and remand for a new trial. Again, if you find for Michael on issues 1 and 2, it would be a remand just on the rape allegation. If you find for Michael on issue 3, it would be a remand for 1 sexual exploitation conviction and 1 rape conviction. So I appreciate the court's time.
May it please the court. Kayla Rayler on behalf of the appellee of the state of Kansas. I'm going to start with issue 1 based on some of the questions that were raised, and I'm going to step away from this microphone. I apologize. It's giving me a lot of feedback. With regard to what evidence there was that these pictures were taken with the intent to arouse the sexual desire or gratification of the offender. The prosecutor's arguments in closing are based on reasonable inferences. Yes, she couched in a we know statement, but that's exactly what they were. They were reasonable inferences based on admitted testimony that the defendant took these photos and that he took them during the course of sexual misconduct that had occurred with the child victim. Now, I don't know about you guys, but I don't know how many people would announce that they're taking child pornography. And I'm not sure that there would be any direct evidence that a person is taking child pornography or that they're going to announce that they're going to go view child pornography. It is common sense that there would be very little, if not none, direct evidence to support that they are going to go view that, and that is the purpose of taking those pictures. That means we have to rely on our common sense and common knowledge. We don't announce that we're going to go do some of the most intimate things that we are about to go do, let alone illegal things. Now, yes, there is no direct evidence, but there is no direct evidence of an innocent explanation for those photos either. For example, if you have a young child and you're a first-time parent, and you have a friend who is a doctor, you might take a photograph and send it to them or say, hey, Dr. So-and-so, can I send you a photograph? Something is not looking right here, and I need some advice. We don't have that. We have the absence of context and absence of exculpatory explanation for these photographs that were on his phone. But we also have the defendant's consciousness of guilt. The photos were deleted. So there is evidence to support that the taking of these photographs were known to have been wrong and that they were deleted at some point in time. Can we prove who deleted them? No. Can we prove what time they were deleted? No. But we can prove that they were on his phone, and then when they did the download, they were no longer there, supporting that they were deleted. And a reasonable inference is that the defendant, who was a law enforcement officer, knew he was not to be in possession of these and that they were child pornography or child sexual abuse material, and deleted them because of his consciousness of guilt of having these items. Now, with regard to the prosecutorial error claims, the first claim of error during voir dire that the prosecutor was bolstering the credibility of the witness, that's not what that was, Your Honors. It appears that Mastel has an issue with the prosecutor's style more than anything. What the prosecutor stated was a correct statement of law with regard to eyewitness testimony is testimony. And if you find her credible, you do have enough to prove beyond a reasonable doubt that he committed these offenses. It's a correct statement of law, and she does not tell the jury, if you believe her, you must convict her. That would be improper bolstering of that child witness, and you simply just do not have that here. With regard to the questioning that was objected to, it's no different than if the question was phrased, you weren't in the room when this occurred, were you? So the fact that he's there for a rape trial and the child victim has already testified about being raped by Mastel really doesn't change the actual effect of the question or the tone or the tenor or the purpose of the question. It was to show that she had no firsthand knowledge of anything that occurred in that room. With regard to improper comments of the defendant's guilt in closing, that was subsection 3 of it. Yes, She used a list of hypothetical terms in one paragraph. But what Mastel forgets is that the following paragraph, she then talks about the child victim's testimony to support her questions and then finishes it up in her rebuttal closing.
Well, but not only does the prosecutor ask rhetorical questions, but the prosecutor answered the questions.
Right. And
Is that an improper comment?
I don't think it is, Your Honor, because it's a stylistic choice in that she is saying, yes, he raped her. And then in her next paragraph, she goes into the evidence that supports that. Yes. Stylistically, would you have done it that way? Probably not. Would I have done it that way? Probably not. That's a stylistic choice. It's not necessarily an error just because somebody's style is different than my style or your style or a defense attorney's style. We all have our own personalities and styles, and closing argument is where that comes out. The other thing I wanted to say with regard to sub point 2 with that questioning that was objected to, we don't know the tone the prosecutor used. We have a black and white transcript, so we can't say how she was saying it to the witness on the stand. You can imagine it, but we have to read it with a flat affect because we weren't there. We don't know how it was said, and the transcript is devoid of the tone and tenor that was used. With regard to the facts not in evidence, I read that closing statement section by the prosecutor the same way that you read it. And in fact, if you looked at the full context of that paragraph, what she's saying is that the sexual exposure that the child victim got was through Mastel. Yes, she had this prior sexual abuse allegation, but he exposed her. There was sexual exposure by him, because when you get to the last part of that paragraph, about halfway through line 12 of page 894, it doesn't say that's the prior sexual exposure. It's just that's the sexual exposure that she had. And I don't think you can parse that out, because the next thing the prosecutor says is that the child victim told you sometimes she's on her back, sometimes she's on top, and then the different directions that it happened. So with regard to that, I don't believe that the prosecutor misstated the evidence. Is it not clear? Sure. But this entire trial.
You have a problem with that, though, because, and I know you didn't write the brief, but for some reason, the state of Kansas did not respond to that claim. And so if it is error, you would not be able to meet your burden of saying it's harmless error. Is that correct?
Well, typically, issues not briefed are deemed waived. I mean, we are here at argument. If the court would like supplemental briefing, the state is more than willing to submit supplemental briefing, but I don't even
think it's probably too late for that.
Probably.
And then also, so the state conceded one error, and that was the what we do know comment. And then we also have the error that was not responded to in the brief. So what do we do with all of that in the framework of constitutional harmless error?
I think that this court can, with regard to a constitutional issue, view it for the first time on appeal. Yes, it's not brief, but you are able to look at those comments in the context to determine whether or not it was harmless or not. And the state's position is that, yes, the simple phrase "we know" is error, but the actual statement after the "we know" is not error. Mastel is trying to make a big to-do out of the "we know." If she simply had said, "I submit," it's the exact same statement that is the real evidence and argument that the prosecutor is making. And with regard to the harmlessness, I would point out that both sides are required to abide by the rules and not comment on the credibility of the witnesses and to not bolster their witnesses. And Mastel's attorney all throughout closing did just that, talking about the truth is this, the truth is that, and it goes both ways. And I think that also has to go into the harmless analysis based on the error that Mastel's attorney committed during closing and throughout the course of the trial, commenting on stuff in violations of orders in limine.
And at the risk of interrupting you, we haven't talked about multiplicity. So let's talk about that.
We can talk about that, Judge, but I can probably make it a lot easier for you. The state agrees with the defense on the multiplicity issue as it is applied in the second trial, because the jury only heard about one instance. It did not hear what was said at the first trial, that he took them on several occasions. So based on the evidence presented at this trial as applied to Mastel, the state agrees. It is.
Wait a minute here. Your brief is contesting this. Are you saying now in oral argument you're conceding the multiplicity issue?
Yes. I did not write the brief. I did not do the trial. I can only follow the law and make the arguments based on what the law is. And based on my reading of the law, that is the correct outcome. I believe the issue, the way it was briefed, was for the possession of child sexual abuse material and not based on the production of child sexual abuse material, which is why I'm conceding. If it were briefed the other way, I think it would have been a concession.
I appreciate your candor.
That's what we're here for. With that, if you have any additional questions, I would just stand on the rest of the briefing.
You still have 3 minutes.
May it please the court. I'll respond to some of the state's arguments here. I think first and foremost, I don't think it's a fair comment on the evidence for the state to get up here and say that there is no innocent explanation for the photos that were on the phone. There is ample trial evidence that Michael did not take these photographs, that Jennifer herself took these photographs, potentially with the assistance of a friend. There is exculpatory evidence that Michael did not commit that offense. So I don't think that
You're asking us to reweigh that? Or?
Not to reweigh it, but just to say, I just want to make the record clear that there's no evidence. The state stood up here and said that it's devoid of any innocent evidence for the photos taken on Michael's phone, but that's not true. I'm not suggesting that you reweigh it, but I am suggesting that there is an innocent explanation for the photographs. And I also think it's important to point out that, again, we're not talking about Michael Mastel's phone. We're talking about an old phone that is set in the living room for everyone in the family to use whenever they want. It's not hooked up to data. I don't think that you can infer Michael's guilt because the photos were deleted. The state stood up here and said, we don't know who deleted those photos. So again, if Jennifer took the photos and it's a family phone that is accessible to everyone, she may not want them viewed by everyone in the family and she deleted them. So I'm simply saying there is an innocent explanation for why those photographs were on the phone. I also think that if your stylistic choice as a prosecutor is to give your personal opinion about the guilt of a defendant, you should probably pick a different stylistic choice. That is an error, particularly when you sandwich it between uncontroverted evidence. You make it sound like it's uncontroverted evidence that your hypothetical and your response are true. You're answering those questions. And I would also like to point out that this court simply cannot meet a party's burden for it. I do not think it would be proper for this court to make a harmlessness argument for the state in regards to the rebuttal closing error that Michael has raised. I think panels of this court have very recently done this, and I believe State v. Conkia Kulabo, the case number I don't have in front of me, but the appellee did not file a brief in that case, and this court reversed on prosecutorial error because it's not this court's job to put on its prosecutor hat and find its errors harmless.
Let me ask you this, though, a little bit different factual setting here. So they have argued harmless error for all of the other prosecutorial areas, and then for whatever reason didn't cover the last instance of the error. Does that make a difference in the analysis?
I don't think so. It's enough to reverse on one prosecutorial error. If you find it's harmless, then the state has a burden to prove beyond a reasonable doubt that that error did not affect the outcome of the trial, beyond a reasonable doubt. And if the state hasn't met its burden, then one error is enough to reverse. And I think that's probably all that I wanted to touch on. Oh, and one more thing, again, issues not raised by the party should be deemed abandoned and waived. The state has not at any point in its briefing suggested a quid pro quo or what's fair is fair. They've never alleged that Michael Mastel or his attorney made any sort of improper closing arguments that then allowed the state to make improper rebuttal arguments. So I think that this court should disregard that comment that was made in oral argument today. And I'm happy to answer questions on the prosecutorial error or any other issues if this court has them.
All right, counsel, thank you very much for your briefs and your arguments. We'll take the case under advisement and get a written decision out to you just as soon as we possibly can.